I'm Sarah Keogh, I'm a barrister at Old Square Chambers. I'm a specialist in employment law and I've been dealing with junior doctor matters for a number of years. Well, I do believe that the agreement is a robust long-term solution to the present gap in the law. It's not designed as a temporary solution. There's no end date to the agreement. It's been future-proofed. I'll give you an example of that. NHS Foundation Trusts currently all use national terms and conditions, but they're not obliged to. If an NHS Foundation Trust decides in the future to move to a different contract for doctors in training, the agreement will still cover that. There are really only three situations in which the agreement will come to an end. Firstly, if the protection against detriment in the Employment Rights Act is repealed. Secondly, if there's a change to the Employment Rights Act to allow this type of claim to be brought against Health Education England. And thirdly, if there's a final determination or ruling which is binding on Health Education England that postgraduate trainees are entitled to bring proceedings under the Employment Rights Act in the tribunal against Health Education England. This is something that I spoke about in the Junior Doctors Committee, and it's been reported that I said there that the agreement was a stopgap until a definitive solution could be found. And that's not correct, and I didn't intend to imply that there's any sort of temporary nature to this agreement, except, of course, where these termination situations occur. The agreement itself is a definitive and effective solution, but it is true that if one of the three termination situations occur, the agreement wouldn't be required, and it would then come to an automatic end, except where postgraduate trainees have already accrued a cause of action or are already bringing proceedings under the agreement. Any ongoing proceedings before the courts will not affect the current operation of the agreement. So if a postgraduate trainee has suffered a detriment as a result of making a protected disclosure, they are fully protected right now. Speaking hypothetically though, if the Court of Appeal did find that Health Education England was an employer under the extended definition, it wouldn't necessarily mean that the agreement would come to an end, and there could be a further appeal to the Supreme Court. However, in order to provide certainty in this type of situation, the agreement provides that where there is a right of appeal available to Health Education England, it can give notice to the BMA and to the British Dental Association that it won't appeal and it intends to be bound by the court's decision. Now, if that were to happen, and I should stress there's no guarantee of that, there would no longer be a gap in the law and the agreement would come to an end. No, they would actually have exactly the same level of protection. As we discussed earlier, the remedies available under the agreement are identical to those available in the Employment Tribunal, and the BMA will fund claims in exactly the same way. The only difference is where the claim can be brought. And the benefit of the agreement is that it provides protection right now without the uncertainty of a prolonged legal dispute. But if a doctor falling under the agreement believes that they've been subjected to a detriment by both their NHS employer and by Health Education England, they can bring a claim against both of them. The agreement contains indemnity provisions as between Health Education England and any NHS employer who signs up to the agreement, so that a court can determine where the fault lies between them. And in an appropriate case, Health Education England might decide to bring an employer into the County Court or High Court proceedings so that the matter would be determined in one forum. What a doctor can't do is claim for the same losses in both claims. So just as the Employment Tribunal would not allow double recovery, the agreement provides that any remedy awarded in an employment tribunal or a payment made under a settlement agreement, for example, would be taken into account by the court in determining what remedy should be awarded in a successful claim under the agreement. As regards funding, BMA members would be eligible to seek the normal discretionary legal support in respect of both claims, subject to the merits assessments we've discussed earlier. What we have done is work very hard in negotiations to provide what I believe is a full and robust agreement which provides an excellent level of protection. And as I said at the JDC, I do personally believe that that's a victory for junior doctors. The BMA have published a range of materials on their website detailing the protection that the agreement offers, and that includes guidance that's been jointly authored by Health Education England and a full written opinion from myself and Mark Sutton QC. If a member requires individual advice though, they should get in touch with the BMA's first point of contact employment advisors as usual.